Orders of the day.
Government orders, government bills, comments, consideration of a motion respecting Senate amendments on Bill C-22, Canada Disability Benefit Act.
Mrs. Qualtrough, seconded by Ms. Gould, moves that a message be sent to the Senate to acquaint their honors that, in relation to Bill C-22, an act to reduce Can I complete here? Thank you. An act to reduce poverty and to support the financial security of persons with disabilities by establishing the Canada Disability Benefit and making a consequential amendment to the Income Tax Act, the House accept these amendments.
Agrees with Amendments 1, 4, and 5 made by the Senate. Agrees with the Senate proposal to make any necessary consequential changes to the numbering of provisions and cross-references resulting from the amendments to the bill.
Respectfully disagrees with Amendment 2 because it raises significant constitutional concerns by seeking to regulate the insurance industry specifically or contracting generally, both of which fall within provincial jurisdiction.
Proposes that Amendment 3 be amended to read as follows. New Clause 10.1, page 4, add the following after line 5, appeals.
10.1, subject to regulations. Well, we're almost done anyway, so. Subject to regulations, a person to any other person acting on their behalf may appeal to a body identified in regulations made under paragraph 11(1)(I) in respect of any decision. A, relating to persons in ineligibility for a Canada Disability Benefit. B, relating to the amount of a Canada Disability Benefit that the person has received or will receive. Or C, prescribed by regulations. Debate. The Honourable Minister of Employment, Workforce Development and Disability Inclusion.
Much, Mr. Speaker. Mr. Speaker, I rise today to discuss, as was said, the government's position on the proposed Senate amendments to Bill C-22, an act to reduce poverty and to support the financial security of persons with disabilities by establishing the Canada Disability Benefit and making consequential amendments to the Income Tax Act. I do so on the traditional unceded territory of the Algonquin Anishinaabe peoples. I'll begin by thanking senators for their attention to this bill, especially the members of the Senate Standing Committee on Social Affairs, Science and Technologies for their study, which resulted in 6 amendments to the bill and 7 observations. Mr. Speaker, each time I have risen in this House on Bill C-22, I've begun by declaring that no person with a disability in this country should live in poverty. And yet many do. Approximately 23% of working-age persons with disabilities in Canada live in poverty, many in deep poverty. The history of how this came to be in a country with as much promise and opportunity as Canada is one of exclusion, marginalization, and discrimination. This history and the resultant financial insecurity and poverty that is the lived experience of many persons with disabilities in Canada is the backdrop for C-22. And it's why we're here today, working together to create a new federal benefit for low-income working-age persons with disabilities. At its core, the Canada Disability Benefit is about poverty reduction and financial security. Mr. Speaker, there is a significant gap in our social safety net for persons with disabilities. The Canada Child Benefit Disability Supplement is available until age 18, and Old Age Security and the Guaranteed Income Supplement are available after age 65, and there is nothing in between. Like the Guaranteed Income Supplement did for seniors and the Canada Child Benefit did for children, the Canada Disability Benefit will lift persons with disabilities out of poverty. Bill C-22 is framework legislation by design. The Canada Disability Benefit will be established and implemented through Bill C-22, which is the legal framework to create the benefit, and a subsequent regulatory process through which the specific details will be established. This reflects our commitment to the disability community and recognizes the leading role that provinces and territories play in providing supports and services to persons with disabilities. Now to the amendments. Mr. Speaker, there were 6 amendments sent back from the Senate. As was said, the government agrees with Amendments 1, 4, 5, and 6, and proposes that the House accept these amendments as is. These amendments enhance Bill C-22 in that they add clarity, precision, and specificity. We also agree with Amendment 3, with a minor amendment. Amendment 3 adds a new clause, Clause 10.1, related to appeals, While Bill C-22 provides for an appeal process to be created by regulation, this new clause gives a right to appeal in two specific areas: benefit ineligibility and amount. The government proposes that this Senate amendment be further amended to clarify that other decisions may also be appealed. This avoids a future legal interpretation where grounds for appeal are restricted to the two specified areas of ineligibility and amount. I thank the Senate for their thoughtfulness on this important issue of administrative justice and trust that they will consider the government's proposed amendment appropriate. Now I'll spend some time on the final amendment, Senate Amendment Number 2, as the government's proposed response to it is to respectfully disagree. Amendment 2 amends Clause 9 of C-22, which concerns the way benefit payments are to be treated in situations such as bankruptcy or insolvency. Amendment 2 adds that benefit payments cannot be recovered or retained in whole or in part under the term of any contract, insurance plan, or similar instrument. I understand the intent of this amendment. It is to address a situation where provincial benefits or insurance payments are at risk of being clawed back or reduced as a result of a payment of the Canada Disability Benefit, effectively leaving the recipient no better off and potentially impacting secondary program and service entitlement. The issue of clawbacks is perhaps the most common concern raised by the disability community. We heard it here in the House as well. Mr. Speaker, the disability benefit and support landscape is incredibly complex and varies significantly across the country. There are different eligibility criteria in every province and territory. There are different definitions of disability, different treatments of other sources of income, different reduction rates, etc. As a result, we have to be mindful of the potential direct and indirect impacts that additional income in the form of the CDB could have on provincial or territory benefit and service entitlement. Since day one, we've been clear that this is supplemental income meant to be in addition to provincial territorial income supports and other forms of income. It is not replacement income. It is not employment income or employment earnings. We explored ways to address this concern through legislation. The challenge is that both contracting generally and the insurance industry fall within provincial territorial jurisdiction. This is why no such provision exists in any other benefit legislation in Canada. Not for the Canada Child Benefit, not for the OAS or the GIS, not for CPP, not for the Canada Workers Benefit. And while the Federal Spending Authority allows the government to create such a benefit, it doesn't allow the federal government to attach conditions in areas of provincial jurisdiction, such as the regulation of insurance companies. Knowing this, we've worked very closely with provinces and territories on benefit interaction. Provinces and territories have expressed gratitude for early engagement. There is consensus that the CDB is intended to be supplemental income, not replacement income, and to make people better off. They share our view that the best way of optimizing benefit interaction is by working together. We have a detailed federal, provincial, territorial work plan that all jurisdictions have agreed to. Once this bill becomes law, we will begin the formal negotiations on agreements with the provinces and territories. We have also engaged with the private insurance industry. The feedback that we've received from the industry is that they would not choose to offset our clawback income that is considered social assistance or a poverty reduction measure. Once again, the CDB is not replacement or employment income. Once this bill becomes law, we will continue to work with private insurers throughout the regulatory process. Simply put, the government disagrees with this amendment because we believe it raises significant constitutional concerns. Both the regulation of private insurance and contracting generally fall within provincial jurisdiction. If we went ahead with this amendment, the likelihood of an individual or organization bringing forward a court challenge would be very high. This would create significant uncertainty and could impact the regulatory process, which could in turn impact benefit delivery. This could very well delay benefit payments. Furthermore, I'm concerned that there would be serious implications for federal-provincial territorial relations. It's likely that the provinces and territories would see this provision as an encroachment on their jurisdiction. This could undermine the work that we've accomplished to date. Therefore, while I understand and share the Senate's concerns around clawbacks, the way to address this issue is to continue with the process that is already underway, not through this amendment to C-22. Mr. Speaker, the Senate amendments we are proposing to accept further strengthen Bill C-22 and do not limit the government's commitment to a quick regulatory process. The amendment we are proposing to not accept, respectfully, raises constitutional concerns and could significantly impair our relationships with provinces and territory and ultimately delay benefit delivery. I thank senators for responding to the disability community's concerns. Both this House and the Senate have improved this bill. This is the emotional part. The Canada Disability Benefit is the result of decades of relentless advocacy on the part of the disability community. This benefit is the culmination of the work of every self-advocate, every activist, every parent, every ally, every organization, everyone who has fought to have disability rights recognized. I said at the beginning of my remarks that we are here working together on this. We've come together on this bill already, and today we did it again. We are on the cusp of doing what every single one of us in this place came to Ottawa to do, to help people, to make their lives better, and to right historic wrongs. Today, we are literally making history. Merci. Merci.
Now, I know we're going to PMB hour in just a few moments, but we do have time for maybe a 30-second minute interaction. The Honourable Member for Kelowna Lake Country.
Thank you, Mr. Speaker, and thank the Minister for her intervention. The last that we had heard was that it was going to take approximately a year to negotiate with the provinces and territories, and also during that time, a year for developing of the regulations. And once this potentially passes royal assent and becomes law. So is that still the timeline that you're working towards, Minister, and will it in fact take a year to develop all of that? So realistically, people should be expecting the disability benefit well a year past this point. Thank you.
The Honourable Minister.
I thank you for your question. That's right. I thank the honourable member for her question. I'm a little discombobulated. Yes, the anticipated timeline for the regulatory process remains at 12 months. So again, as always, as I've said, the quicker we get this to royal assent, the quicker we start that 12-month clock.
So when we come back, the Honourable Minister will have 4 minutes of questions and comments. It
being 5:30, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Mr. Canning, seconded by Ms. Barron, moves that Bill C-219, an act to enact the Canadian Environmental Bill of Rights and to make related amendments to other acts, be now read a second time and referred to the Standing Committee on Environment and Sustainable Development. Debate. The Honourable Member for... Oh, we have a point of order. The Honourable Minister of Tourism.
Speaker, I give notice that with respect to consideration of government business number 26, at the next sitting of the House, a Minister of the Crown shall move pursuant to Standing Order 57 that debate not be further adjourned.
Debate. The Honourable Member for South Okanagan, West Kootenay.
Well, thank you, Mr. Speaker, and it's with great pride that I stand here in this chamber this evening to begin debate on my bill, C-219, the Canadian Environmental Bill of Rights. And I first want to thank Linda Duncan, the author of this bill, who introduced it on 4 occasions over 11 years during her time as the Member of Parliament for Edmonton-Strathcona. And on one of these occasions, it did pass its second reading, but unfortunately died when an election was called. There are environmental bills of rights in Ontario, Quebec, the Yukon, Northwest Territories, Nunavut, but until last night, there was no federal law that explicitly recognizes the right to a healthy environment in Canada. With the passing of S5 that updated the Canadian Environmental Protection Act, we now have a federal statement of the rights